Those of you who travel to the UK, outside the House of Commons, there is a square where people who want to picket and demonstrate come there, carrying their placards, hurl all sorts of obscenities at their lords, the House of Commons members, the state, including the Prime Minister, including the Queen, now the King. And when their time allocated is over, they quietly walk away without hurling a rock, without the police brutalizing them, without any confrontation with anybody. I wish it was the same in this country. Kofi Annan always prided himself as a man with a soft voice, but a strong message. You don't have to hurl a rock at a person you are talking at for you to make your point. All you need to do is to be heard and demonstrate that this is the way you want things to be. So we would also want to hear the voice of the civil society, you, the lords, on how we can bring order to our right to picket, to demonstrate, to sit in, without destroying property, without deaths, and without unhelpful confrontations between the police and the citizens. On a lighter note, honorable judges, in the same way that King Lemuel advises his son in Proverbs, I wish to give the judiciary a little credit for she has become a radiant woman, and all her loving works of righteousness with respect to that particular decision deserve to be admired at the gateways of every city. You know, many people out there never appreciate the judiciary until they are in problems. Engineers can go and design bridges without any reference to you. When they quarrel, they run back to you. Doctors, if they mess up with their patients on the operation beds, when they are in problems, they run back for solace from you. When we in the political arena quarrel and don't agree, we run to you to tell us who the genuine winner of an election is. And many others. So you hold a very critical position in society. Honorable judges, in our work as Parliament, we have been keen to ensure the discharge of our legislative representation and oversight roles upholds fundamental rights and freedoms to the fullest extent. Through tools such as questions, petitions, and statements, legislators have raised issues in the House on cases of violations of human rights for action and sought responses from the executive and relevant bodies. Additionally, Parliament has enacted laws that implement human rights. Notably, the National Assembly is presently considering the Persons with Disabilities Bill 2023, which seek to implement the rights of persons with disabilities as enshrined in Article 54 of the Constitution. With respect to oversight, Parliament and its committees have conducted various inquiries and investigations on violations of human rights and commended the appropriate action and remedies to these grievances. Presently, committees of the National Assembly are engaged in inquiries relating to alleged human rights violations by the British Army Training Unit in Kenya and the alleged historical and systemic dumping of toxic waste in the northern parts of the country. Honorable judges, in support of key actors that promote and enforce the Bill of Rights, the National Assembly has consistently sought to provide adequate budgetary allocation to the justice sector within the available fiscal envelope. This has seen the gradual increase of allocations to the judiciary and other key actors over the years. I think in the last budget, even with the fall of the finance bill, we raised your budget to over 19 billion to enable you discharge your responsibilities. The Chief Justice tells me that's not enough, and I do know it is not enough. Even as at the legislature, we demanded and expected 68 billion, but we only got 49. In support of key actors that promote and enforce the Bill of Rights, the National Assembly, no, sorry, I've read that. I'm keenly aware of the critical role of the civil society and our development partners in supporting the judiciary in its enforcement of the Bill of Rights. Indeed, the convening of this summit has been made possible through such support. However, it is my enduring belief that we must respect and discharge the responsibilities that accompany our wholehearted effort to enforce human rights. Honorable judges, observance and enforcement of human rights is a responsibility that attaches to all of us. In addition to highlighting any real or perceived violation of human rights, I wholly encourage the civil society and other development partners to lend their voice in condemning injustices committed against state actors and private individuals whose rights are negatively affected by the actions of other citizens. For some reason, a demonstration to enforce a particular right is not deemed as successful or impactful in this country unless there is destruction of property or loss of lives. The judiciary has stood as a bulwark against any threats to the rights enshrined in the Constitution. During the 3 changes in its leadership, it has guided us on key jurisprudential questions, including those touching on legislation by Parliament. In particular, the Supreme Court has recently guided on the parameters that a court should consider before declaring a statute to be unconstitutional. This is one area where, Judge Ogol and your team, I want to urge you to give the public some degree of consistency and also to now adhere to what the Supreme Court has said, which is a principle espoused all over in comparable jurisdictions, that when a bill is passed by Parliament, there is a presumption of constitutionality of that bill, and anybody who comes to court to challenge it, and as they should, because Kenyans have the right to come to court and challenge the constitutionality of any bill. The moment such a matter is brought before you, in my view, and in view of now the Supreme Court, it automatically raises tribal issues. And it is good to hear both parties before you make a declaration. I give you an example of a bill that was frog-marched to court to be declared unconstitutional. The bill had 68 sections, and the challenger pointed out 18 of those sections as being unconstitutional. Strangely, the judge declared the entire bill unconstitutional, even the uncontested sections. And you know, in Parliament, we vote on each and every clause of a bill, including the title. So I want to believe that the judge, in his or her wisdom, found that even the title of the bill was unconstitutional. Even the definitions in the bill were unconstitutional. Even the memorandum of objects in the bill were unconstitutional. Even the saving clauses, even the commencement date were unconstitutional. I found that a bit strange. But the Supreme Court has put some direction to that. I commend the judiciary for the admirable work that it has done in discharging its onerous mandate of enforcing the Bill of Rights. Time and again, as expected by the framers, the elastic limits of our Constitution have been tested. Invariably, the judiciary has risen to the occasion over the last 14 years and guided the nation on the constitutional way forward without fail. The judiciary has stood as a bulwark against any threats to the rights enshrined in the Constitution. During the 3 changes in its leadership, it has guided us on key jurisprudential questions, including those touching on legislation by Parliament. In particular, the Supreme Court has recently guided on the parameters that a court should consider before declaring a statute to be unconstitutional.